Hey everybody, Derek Christensen here today. I wanted to talk to you about the tricky sales tactics that some estate planning attorneys out there undertake to get more money out of you. But before I dive into that, I wanted to let you know how to reach out to me. You can find me at my email, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me at my website, www.legionlawpllc.com. So with that, let's dive right in. I had to talk about this because I had a potential client meeting just the other day, and unfortunately I found out that she went and talked to other people or other attorneys. Nothing wrong with that. In fact, I encourage it, but I found out that those other attorneys were kind of doing what I would argue shady sales tactics. Unfortunately, attorneys have the advantage to just confuse the daylights out of you, promise you that you're going to get what you want, and then charge you a massive bill, and you have no idea what you're looking at, and they just say, sign here, I promise everything's okay. It's frustrating, and I personally want to change that in my industry because, the two biggest concerns people have when working with attorneys is that it's going to cost a lot, and I'll have no idea what's going on. So hopefully these videos are helping you understand what's going on, and hopefully you understand what the costs are. If you're going to work with me, you know you're going to pay once, and that's it. But other attorneys do other things differently. So let's dive into it. There are three different things that come to mind. The first would be charging by the hour. Now, sometimes it's appropriate to charge by the hour. In advanced estate planning, where you are worth $12 million, $20 million, and you're worried about estate taxes, and we have to create entities and transfer assets over and do crummy letters. And what I'm trying to say is that there's a lot of work in advanced estate planning where we are trying to help you avoid and lower your estate tax. However, most people are not in that category. Most people have way less than $12 million to their name. Therefore, oftentimes, they're more worried about just standard estate planning. In standard estate planning, there is no excuse to charge by the hour. And in fact, I would argue that it creates a system where you want to be inefficient as an attorney to draw up the bill higher, charge more, exactly. So I am not a fan of that. It's not prohibitively bad per se, but it is sort of a red flag in my opinion, because unless you have something crazy going on in your family situation where people don't get along and you have to get signatures from everybody and everybody is all upset at one another, other than that, normal circumstances for 99% of people, you really should just be charging a flat fee where you pay once, you get your product, you sign your product, you're done, kind of thing. So there's that. I could understand hourly afterwards, after all the signing and stuff, if there's a lot of work to do afterwards where you're transferring bank accounts, transferring assets into a trust, retitling things, et cetera, et cetera. But that is sometimes happens, sometimes doesn't. It's usually an optional product to go undertake. So either way, hourly is kind of a red flag to me. It's not, again, as bad as these other things I'll talk about, but look out for that for sure. The second thing that I really, really dislike with people in estate planning is that they will oftentimes sell a will on purpose over a trust. They won't even mention a trust. They'll say the trust is inappropriate and that you shouldn't have a trust. And then they know that they're going to get the probate later. So fun fact, probate is probably the most lucrative part of being an estate planning / probate attorney. Probates run from $2,000 at the very bottom to $10,000 on average. And they can go way higher than that if there's a family contest, if there's litigation and everybody's falling apart. So me as an attorney, if I'm trying to make the most money out of you, if I charge you once for a will, then I can charge you again for a probate because wills have to go through probate. And if I put my name all over that will and I look really fancy and nice, then the person who's going to pull up that will and read it says, oh, here's an attorney right here. He drafted it. He obviously knows what's going on, so let's hire him for the probate. And therefore, it's called double dipping. It's crazy. So either way, if you don't have your attorney talk to you about a revocable living trust, and if you don't understand that a will is going to go through probate and that a probate is way more expensive than just setting up a trust, if you don't hear that at least once while talking to your attorney, that's a big red flag, because in my opinion, those attorneys are knowingly giving you a will and then trying to double dip later on. Now, any will is better than no will. So don't get me wrong, it's better to have something than nothing. But the best for most people is to have a trust in place, transfer assets into that trust, and then all those assets avoid probate, and you don't have to go through probate in the first place. It's cheaper for you in the long run. It's less. I make less money in the long run as well. But I think that's the right thing to do, personally. So again, if you want to have a will and you don't want to pay for a trust right now, you think it's too expensive to set up a trust, that's totally fine. But if they don't talk about trusts at all, and they don't mention that wills are going to go through probate, and they don't mention how expensive probate is, those are some pretty serious concerns, because I would argue that attorney is purposefully not telling you the consequences of having a will. And last but not least, it kind of ties into that. I made a video about this earlier, but testamentary trusts is kind of the last thing. I mentioned the double dipping, sell a will, then get the probate. Well, a testamentary trust is where you have a trust inside of a will. And so you can say, oh, well, I'm making a more complicated will. I'm making a will that has a trust inside of it. Therefore, I need to charge you even more for this will. And then this testamentary trust can't get activated until you go through probate. So I can charge you a more expensive product up front, and then I can still get a second, dip. So I strongly disagree with that. It's really messed up. And again, that's how attorneys make the most money out of the lifetime of a client. Younger attorneys like myself, we can usually outlast our older clients. And so we have in the back of our minds, oh yeah, I can try to get their probate. But at the end of the day, if we're looking out for what's best for you, we're looking for what's fastest and what's cheapest over the lifetime of your, to accomplish the objectives that you want to accomplish. And if those objectives, which most of them should be, is to pay the least and go the fastest through probate, a revocable living trust is absolutely important to talk about. If you don't talk about it, I would argue you're doing it wrong. So either way, those are three things. Again, hourly, charging you a will and not even mentioning a trust, and trying to do a testamentary trust versus not even a revocable living trust. So either way, take a look into those options. If you hear that while you're talking to an attorney, probably should talk to another attorney and another one until you finally hear someone talking about trusts, wills, consequences of probate, stuff like that. Either way, this has been a longer video than I expected, but feel free to reach out to me. Email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, where you can go to our Contact Us page and schedule a free consultation over the phone directly on my calendar at www.legionlawpllc.com. So with that, have a great day.